I know I am guilty. Should I just go to the court and plead guilty?
I hear this all the time. People always want to know how I can defend them or advise them to plead not guilty if they know they are in fact guilty. The reasons are many. First off, the law distinguishes between those who are factually guilty and those who are legally guilty. Just because you know you committed the act and were subsequently arrested for the act does not automatically mean that you are guilty. In any criminal trial, the state is required to prove you are guilty beyond a reasonable doubt. And further, you cannot be compelled to testify against yourself. This means that the state must have sufficient evidence to convict you at trial. The legal standard of beyond a reasonable doubt required to sustain a criminal conviction is much higher than the standard of probable cause required to make an arrest. A Connecticut criminal defense attorney will attempt to poke holes at the state's case by showing that certain evidence, for example, witness testimony, is unreliable or inadmissible if it was obtained in violation of your constitutional rights. A second reason lies in the concept of prosecutorial discretion. This discretion afforded a prosecutor to drop or reduce charges often allows a person who is legally guilty to escape conviction. An experienced defense attorney will know what factors will increase the likelihood of your charges not being prosecuted. For example, if you are charged with a crime rooted in drug or alcohol abuse, a prosecutor will often be less likely to pursue prosecution if you are receiving substance abuse treatment. Additionally, your lack of criminal history may mean that you could potentially receive diverted prosecution and instead be placed in a program such as the alcohol education program, drug education program, family violence education program, or accelerated rehabilitation. These programs do not require any finding of guilt, and if successfully completed, could lead to the dismissal of your charges. Lastly, even if you are pleading guilty, it is imperative that you have a criminal defense attorney to negotiate the least restrictive sentence possible. Your attorney will present mitigation and character evidence on your behalf. This could mean the difference between jail and probation.